Hello, this is Tom, aka Gedeon here for Tabletop Taproom reporting. Oh, I'm in the wrong room. I'm in the tavern. Oops, my bad. Virtual background did not get changed. Big goof. All this I did to get ready and I screwed it up. All right, here we are in the courtroom. Courtroom reporting. And we have news. We have news in the TSR New York libel case against Erik Tenkar. And yes, the case has been dismissed. We're going to get into that. First, I just want to say thank you for watching the video. Thanks to my subscribers. You guys are great. And, I figured I'd dress up, wear a tie, get some good drink. And we would cover this today. This is the judgment by the judge, 30 pages of it. Let's see if we can discern the judge's tone as we work our way through this. My first highlight that I did in here is that, let me just get caught up. Hello, Elfbait. And yes, tortured litigation, judge's own words. My first highlight here is Lanasa's claims against Rachel must be dismissed because he failed to timely serve process on her, and Lanasa's claims against Erik must be dismissed for failure to state a claim. This is the essence of the motion by Erik and Rachel. And so the judge is going to largely be dealing with this throughout this entire document, and he goes into it in quite a bit of detail. So we then get to, this is, which page was this? Page 5. Lanasa, I found this fascinating. I found this very fascinating. Lanasa attempts to assert claims of severe humiliation, loss of standing in the community, loss of self-esteem. So, it sounds like the man's suffering. He's lost self-esteem. He's endured public disgrace. Loss of standing and respect within his own family, and severe and extreme emotional distress. Now, the piece that I want to focus on is the loss of standing and respect within his own family. We only are really familiar with about 3 members of his family. One is his daughter, and I really don't think, kids look up and idolize their father. I don't think it's the daughter. There's the father, who just within the past 6 months actually, posted something in support of Lanasa. So I don't know if it's the dad. It could be the dad. And then there's the spouse. And I don't know. She hasn't really said much in quite a long time publicly online in support of Lanasa or concerning this. So whoever it is within his family that is not their opinion of him has dimmed. Apparently, he's suffering from that. That's a loss of standing and respect. He's lost respect in the eyes of somebody in his family. Don't know who it is, but we'll just maybe leave that one alone, I think. Hello, Rum Rogue. Cheers. So that statement was interesting to me. Then we get this. Lanasa requested leave to amend his complaint, again, to remove Lois's name, that's Erik's mother, as a defendant, and to strike the assertion that Mr. Lanasa has no criminal convictions, because Erik proved conclusively that he had criminal convictions. So, the fact that he had asserted it 3 or 5 times repeatedly in several motions to the court, several filings to the court, that was kind of false. And he was saying, hey, he called me a criminal. That's defamation. But it actually was true. And now, because of this court case, it's become part of the public record that, he is a criminal. He's convicted. He's got criminal convictions. So this is an important point here about filing leave to amend the complaint. And the judge said, all right, you can amend the complaint for those 2 things. And when the judge gives you permission to amend the complaint, you must amend the complaint per what the judge authorized and not go off half-cocked. The second amended complaint not only removed Lanasa's allegations against Lois, but also added allegations against Rachel and named her as a new defendant. This is a sticking point. And the plaintiff has the burden to establish subject matter jurisdiction. Okay, so the court cannot lawfully exercise personal jurisdiction over defendant who the plaintiff has not properly served. Rachel was never properly served. We made this point. Erik and his lawyers made this point. Why is she being, the judge, and the judge is going to camp on this point. Very importantly here, the complaint must state a facially plausible claim for relief. The claim is facially plausible if the complaint alleges enough factual matter to suppose a reasonable inference that the defendant is liable for the misconduct alleged. Now we get down to the actual discussion. The court addresses the subject matter of jurisdiction first because the court cannot proceed further with this action if it has no power to adjudicate. This is in reference to the Rachel matter. And scrolling down, he kind of goes into this. Oh, we learned that that Justin spent, what was it? Total losses, $160,000. He's claiming legal fees, $130,000 in this case. And, I guess that was money well spent, maybe. It shut Erik up for a little bit of time. So I guess money well spent for Justin. Hello, Terry. So, yeah, we get down here. The court declines to excuse Lanasa's failure to timely serve Rachel for the following reasons. Lanasa's attorney apparently mistakenly believed that the service deadline was April 25th, 2024, which would have been 100, not 90 days after the date Lanasa filed a second amended complaint. Though the court must excuse a plaintiff's failure to timely serve a defendant for good cause, a mistake by the attorney is not good cause. So that's the good wife in the background playing the Chung Chung from a certain TV show. The court declines to excuse. Lanasa's not going to be excused for his lawyer's failure. Considering the factors listed above, all of the other relevant equitable circumstances in this case, a discretionary extension to perfect service is unwarranted. They're saying, look, because of all this case is so messed up. Okay, all the circumstances, your lawyer's wearing clown shoes. You have no case. We're going to get into all that. The judge is saying, I am not going to extend this. This is just ludicrous. After the parties agreed that Lois Steen has no connection to the case, Lanasa filed a letter noting his intent to amend the complaint to remove her as defendant. And the assertion that Mr. Lanasa has no criminal convictions. Because Lanasa already amended his complaint once, he could amend it again only with the court's leave. Let you amend it once. You don't get to amend it again unless I say you do, is what the judge is saying here. But they slipped in a third, essentially a second amendment by putting Rachel in there, which was improper. And we noted that before in previous video. But here the judge is saying bad and slapping him for it. So contrary to that order, Lanasa added allegations regarding Rachel and named her as a new defendant. His letter did not ask leave to amend to name Rachel, only to remove allegations regarding Lanasa's criminal record and allegations regarding Lois Steen. He's saying, you didn't ask permission. This is the judge being irritated, making a point. You did not do things the proper way. And I'm not going to allow that kind of, shenanigans in my court. So Lanasa's erroneous reading of the court order allowing him to remove Lois Steen as defendant as allowing him to replace her with a new party was objectively unreasonable. The judge just called Lanasa unreasonable. Thank you, Judge Matsumoto. Is that how we pronounce his name? I just love that. Then he says there's a strong policy need for courts to enforce sanctions against parties who, having proper notice and opportunity to comply with the rules with the court's orders, nonetheless fail to do so. I think this is a hint to the Bar Association for the clown shoes lawyer in this case. Actually, I really think this is the judge kind of going nudge, nudge, wink, wink to the bar with that statement. Thus, the circumstances of this case, Lanasa would not have been entitled to discretionary extension of the service deadline, even if he had requested one. He says, "Look, I'm not gonna order it because he didn't ask. He's not entitled to it, number one, but he didn't even ask for it, so you don't get it." That's just the judge being really thorough and really irritated. The court next concludes that Lanasa fails to state a claim for defamation. So because they failed to serve Rachel, they're going to dismiss on Rachel without prejudice. We'll see that in a minute. Now here we get into this whole stating of a claim. The failure to state a claim. This was the second reason for dismissal asked for by Erik and his wife. The court concludes that Lanasa fails to state a claim for defamation, intentional infliction of emotional distress, or prima facie tortious conduct against either defendant under New York law. So we're going to get into this. The court declines to apply. Now, this is where it gets good for Justin. This is where he gets a win. Right here, the court declines to apply New York's anti-SLAPP law to dismiss the action to award cost or attorney fees. First, the Steins have not maintained an action, claim, cross-claim, or counterclaim against Lanasa, which is necessary to attain a cost or fee award under the statute. So because they did not counterclaim. Now, what I understood, what I had been told behind the scenes, from somebody who had some knowledge of the legal ins and outs, was that by not bringing a counterclaim, it actually put them in a certain position that benefited them in this case. So that was like a choice they made, but now it has unfortunately worked out in Lanasa's favor. He's not going to have to pay Erik's court cost and attorney fees. So they're not going to apply that because the grounds for that happening are under the dismissal rules within the New York State statute. And Erik sought a dismissal under the federal civil court rules, and they're two different things. And so the judge is saying, these are different things, and I'm not going to do this. So Erik's not going to get anything out of this. Largely because he didn't counterclaim, but also because the statute's rules for dismissal are one thing and the federal court's rules for dismissal are something else. And he got a dismissal. It's like, all right, we got to get this dismissed and we got to do it one way or another. And you're like, well, all right, we got four paths to dismissal. You can do it this way, this way, this way, or this way. Erik got it done. And so he's going to have to eat the court cost, unfortunately for him, which is too bad. I really looked forward to seeing him own something like Dungeon Hobby Shop or some property formerly of new TSR fame. So further, the anti-SLAPP statute makes costs and fees available only when the court dismisses the action based on the statute's dismissal provision, but does not purport to make them available to parties who obtain dismissal under federal. All right, yeah, so I was just explaining that. Now, we're going to get into the libel and slander. And the judge just says, look, libel and slander claims are going to be handled together because they're essentially the same thing. One's spoken, one's in print. And he just points out that to state a claim for defamation under New York law, the plaintiff must allege, one, that the defendant made a defamatory statement concerning the plaintiff. That two, that statement was published to a third party. Three, the defendant's conduct met the applicable fault standard and the statement was false. And five, that the statement caused the plaintiff damages. Now, he deals with the fault standard. Since Justin is a public figure, the plaintiff is a public figure. The applicable fault standard is actual malice. If Justin was not a public figure and a private figure, just a regular Joe Blow citizen, all he'd have to show was negligence on Erik's part. But he has to show actual malice, that Erik meant to harm him. He meant to just get him. So let me just get caught up on some statements. Wizard Tower, you're here. You're okay. Theatis, well, yep. I feel bad for Erik. He should not have to eat the cost there. And Wizard Tower says he eats the cost, but so did Lanasa. I think Lanasa's costs are higher. He's alleging 130,000, 135, over 135,000 in lawyer fees, all told 160 in court costs and everything. So, but I think Erik's costs are less, but I don't know. He's not told me the amount, so I can't specify. But so the whole he's got to show actual malice on Erik's part. Lanasa fails to state a claim with respect to most of his alleged instances of defamation because he failed to allege that statements at issue were defamatory. He just goes, I've been defamed. Rule in my favor. That's it. And the judge is going, he failed to just even demonstrate anything. The court need not, and we made this point before, the court need not review each linked YouTube video to discern whether the statements were defamatory in context. He further explains that a plaintiff cannot avoid Rule 8's requirements to provide a short, plain statement of his claims, simply overwhelming the court with lengthy exhibits without context and assigning, now watch this, and assigning the court the task of reviewing them and searching for plausible claim. Yeah. That's the judge being like, excuse me?
I'm not doing your work for you.
Do your own damn homework. That's how that translates. That's the judge going, I'm not doing your work for you. You were supposed to do this.
This is the point where I think that the judge has to be thinking, this is why I went and spent all those years and all that money for law school.
Are you guys hearing Tammy? All right. I don't think I put this on unidirectional. There we go. I'll get that on unidirectional. And let me just double check real quick. My audio is good. Yep. So I don't know if you guys heard Tammy say there, but this is where the judge is thinking, I went to law school for this. Yeah, you did. And you ended up with this court case. So
pick the short straw.
Then we get this further comment. First, many of the statements described in Lanasa's second amended complaint. So that was the first complaint. And he goes, then many of the statements in the second amended complaint are non-actionable opinions, like calling somebody an ass. It's a non-actionable opinion. He defamed me. Why? Because he called me an ass. Well, you might actually be an ass for wasting the court's time. Honestly, that might actually be the fact that you brought it to court might make you an actual ass. It's something that's actually a real a real fact with that. So, absent more context, which Justin Lanasa has not alleged, any reasonable reader would interpret the statements as opinions, not as facts. So this is the judge saying what Erik said would just be like, it's reasonable that it's opinion, and reasonable people, you, me, and everybody else, would interpret these as opinion, not facts. Further, some of the alleged statements are insults. Statement amounting to no more than name calling or general insults are not defamation. So when Erik called him an ass, that's not defamation. And we knew that. We had a legal expert say that to us that insults are not defamation of character. The Stein statements that Lanasa used anonymous emails and was an online entity, and his company Dungeon Hobby Shop was for profit, are not actionable because the statements do not expose Lanasa to public contempt, ridicule, aversion, or disgrace.
Which is the defamatory part.
Right. It is unclear from Lanasa's allegations what those statements were supposed to imply, if anything. The judge is kind of saying here, your point is? Same goes for Erik's allegedly threatening statements towards Lanasa, which imply nothing about Lanasa. So when Erik made some comments about lead poisoning, there's an implied threat there, but it's not defamatory towards Lanasa. It implies nothing about Lanasa. It just simply implies something about Erik, that you come to my house to cause trouble. I'm letting you know. House is defended by 9mm lead, I think, or something along those lines. So finally, through the remaining factual statements have objective truth. There were some remaining statements that did have objective truth and implicate Lanasa's character, at least to some degree. Alleging that the Steins accused Lanasa of not paying his employees, of trying to dox them, and that the Steins claimed that Lanasa was kicked out of the military. Lanasa still has not stated a claim with respect to those statements because he failed to plead that any of them were false.
He didn't say any of them were not true.
Right.
He just said, hey, he said these things.
Well, I think the reason he didn't, one reason why he might not have argued that they were false was because maybe they were true.
But also,
because
he has a lawyer.
We've seen the evidence where somebody, complained that he was not getting paid by Lanasa. We've seen, we've seen some of the records from his military career where there was an assault on the Army, and then suddenly he leaves the Army.
But put that aside.
Sure.
He has a lawyer that is supposed to craft this stuff. Isn't some of the basics like, I'm defending you? And even if Lanasa didn't have the insight to say, but all those weren't true, the lawyer should know to do that.
Well, the lawyer also knows that if he goes in the court and argues something that's not true, he can get in trouble for that.
He also counted to 100 when he was supposed to count to 90. So there's that.
Well, there's that. I mean, maybe we should excuse the lawyer for, incompetence or something. I don't know. Here, paragraph 22 of Lanasa's second amended complaint, the only paragraph arguably complaining any falsifiable defamatory matter, simply begins with a boilerplate conclusory statement that the Steins made knowingly malicious and intentional and false defamatory statements. Just slapping boilerplate saying they defamed me doesn't make it so. And then proceeds to list a litany of examples without any detail explaining how those statements are false. For defamation of character to go forward, the statements have to be false. And he didn't demonstrate that because Lanasa has not alleged the existence of any defamatory statement along with factual allegations supporting a reasonable inference of the statement was false. Lanasa has for the third time.
Can you go back? Because you skipped a juicy part, which I love.
Oh, which part did I skip?
That says right after that about how he, gave me all this stuff without any examples or details explaining how. He then says, Lanasa's pleading strategy evidently was to prioritize quantity over quality, throwing as many allegedly defamatory statements as he could at the wall to see what would stick. That strategy failed. He simply described some very nasty opinions and commentary that may or may not have been true.
He might have had better luck throwing dirty underwear against the wall to see if it sticks, quite honestly. But yeah, his strategy was quantity over quality, and then there was no substance to any of the quantity. That was a good statement. I was looking for that. I guess I didn't highlight it. So because Lanasa has not alleged the existence of any defamatory statement along with factual allegations supporting it, for instance, I read this. He failed to state a defamation claim against the Steens. His claim must be dismissed. Wow. Now he deals with the intentional, he's got to deal with each part of it. The intentional infliction of emotional distress occurs when the defendant engages in extreme and outrageous conduct with intent to cause the plaintiff severe emotional distress, and does in fact. So on one hand, one cornerstone of this is that Erik had to engage in extreme and outrageous behavior with the intent to cause emotional distress. And the second part is that it must in fact cause emotional distress. And there's like a little bit of a sure on that you were emotionally distressed. There's a subtext here of that in this document. Lanasa failed to state an intentional infliction of distress, emotional distress claim, because his allegations against the Steins do not describe an extreme and outrageous conduct. Thank you. Erik and his wife were exercising their Second Amendment. They said factual statements. There was a few insults. I've glossed over a few of them in here. There was one that was quoted from Rachel that was, the words are slightly bleeped out in here. That was kind of insulting and vulgar towards Lanasa, but basically they spoke the truth, and it was not outrageous for them to do so. It was did I say the exercise of their Second Amendment? That is wrong. Yeah. First Amendment. Yeah. Second Amendment is about the lead poisoning. Yeah. Now, this next section, because he alleged a prima facie tortious conduct, this gets complicated, and I don't want to try to explain it because your eyes will just glaze over. So let me just.
Our eyes glazed over.
Yeah. So this is the second time this phrase is in here. Highly disfavored, making this the emotional distress is highly disfavored by the courts. Prima facie tort claims are highly disfavored, meaning they kind of just poo-poo them and push them aside. So you really got to work to prove this. And they've done nothing to prove nothing. They just said, he was mean to me, give me money. And that's it. And, they made no claim. They showed nothing. And so the court may not allow a plaintiff to proceed on a prima facie tort claim as a catch-all alternative for another claim that cannot stand on its own legs. This is the judge saying, like Matsumuzo, I imagine that's a Japanese name, but if he'd been from like down south, Carolinas or something, he would have said, that dog don't hunt. So he's saying this thing don't have legs to stand on. The dog don't hunt. I'm not going to allow a catch-all to just be, well, I'll just throw this in there and try to win on this. and the judge is saying, I ain't allowing it. That's just bogus. Let me catch up with a few comments here. So Wizard Tower says, danger is when you say something is not true in a complaint, when you open up, you then open up the accusation being proved as true. That is correct.
Sure.
So if you say you're not a criminal and if somebody shows a court record where you've been convicted of a crime, that makes you a liar. Well, I mean, what normal people will call a liar. The judge carefully didn't call him a liar and was very generous. So if someone calls you something, i.e. a criminal, and you deny it, then you open up the defendant the chance to prove it being right and true.
Well, the whole thing about this part is that it's supposed to be, or maybe you haven't gotten to this part about it being extreme and outrageous.
Yeah, we just did.
Okay, so extreme, and this is not extreme or outrageous is basically what he says, and that the bar for that is so high. Yeah. So high. Like, I think at one point they mentioned, like, in New York, when it's been appealed, it's no one's ever won using that because the bar is so high.
Yeah. So RPG Grandma, how you doing? She says extreme and intense behavior meant to cause distress, like stalking people on the internet, filing lawsuits, doxing with fake accounts, going after people's families and calling everyone corrupt. And I would add maybe, calling someone's kid with special needs really derogatory terms that we don't use anymore, sending fake autopsy pics to someone whose daughter had passed away, claiming that was her, threatening to send AI produced porn pictures of somebody's wife to her place of employment. Yeah, that would work. All right, RPG Grandma, you go back to work. Thank you for checking in. And multiplayer dungeon, looking good, man. Great stream setup. Thank you. It's just a green screen, and I have a lot of ties going back many years.
He's not kidding.
There might even be a tie in there going back to when I attended Catholic high school.
Oh my good grief. So they're really old.
Well, plus I got some of my dad's ties that we saved.
Oh my gosh.
Even that. So leave to amend.
Oh wait, before that there was one juicy little part that I highlighted because we highlighted
different things
separately. No, I've highlighted all the same things, which has been funny. Empty bluster. He called it empty bluster. I love that. The court finds those statements reasonably understood as empty bluster and not true threats of physical violence. Like for the judge to say empty bluster,
Oh, what was the other thing the judge say? Bald.
Oh yeah.
Bald assertions.
Yeah.
And now I read that and I interpreted bald assertions because, I'm familiar with the word bald, as in bald-faced lie.
Yeah.
And I'm familiar with the term assertions.
Right.
And but we looked it up, and when it's used by a judge, it actually means a bald assertion is one for which there is no evidence backing it up. You just say, he's mean to me. You have no evidence of him being mean to you, but look who just showed up.
It's okay. Keep on.
Hey, VGAPMI. Okay. Welcome to the show. Video will be recorded, documented, and used in a lawsuit that will be successful.
Okay, keep going.
Don't
get distracted.
So, having concluded that Lanasa failed to state any claim against either defendant, the court further concludes that Lanasa should not be granted leave to amend his complaint again. On the one hand, a court should freely give leave when justice so requires. The judge says, normally, yeah, if justice so requires, a court could give leave for a case to be amended yet again. But then he says, on the other, leave to amend is a matter of discretion, and a court cannot err in exercising that discretion by failing to grant a request that was not made. So he's saying, you didn't even make the request to do that third amendment. You didn't request it. You don't have leave to do it. And I'm not going to grant you an extension so you can. Done. That's what you get for not following the rules, Fiji. Here, the Stein's motion to dismiss explicitly requests the court to deny leave to amend. NASA declined to respond to that argument. He didn't respond to that argument. The court sees no reason to protract this tortured litigation. There it is. Tortured litigation. The judge called this tortured litigation. Even further, when Lanasa had clear opportunity to justify another amendment and simply refused to do so. So if you had actually filed to amend, to add Rachel to the case, you could have. The judge would have extended that to you, but you didn't do it. So the judge is saying, too bad. Too bad, so sad. You're going to lose on that point. Here, after Lanasa filed his original complaint, the court explained to Lanasa in detail. So he's going all the way back to the original complaint. The court explained to Lanasa in detail at a conference the pleading deficiencies he had to remedy in order to state the claim. Reminding him, there were a lot of deficiencies. We explained to you in detail. Please fix these things. And his counsel,
this is one of my favorites.
A licensed attorney is presumed to know what facts he would have to allege to survive a motion to dismiss. That's a backhand to the lawyer, honestly. This is what you get when you shop around and find the cheapest lawyer you can get. Or when all the attorneys say, yeah, no, this case won't float. And you finally find one who's desperate enough to take the case. This is the kind of representation you get. Somebody who is presumed to know what he's supposed to do in court and clearly doesn't know. And that's nobody's fault but the plaintiff's. Lanasa has neither requested leave to amend nor given the court any reason to believe that he could state a claim if allowed a fourth opportunity to do so. Accordingly, this case is dismissed finally. I love the judge putting in the word finally. With prejudice and without leave to replead. And then the conclusion is simply a restating in nice legalese. And the clerk of courts is respectfully requested to enter it in judgment. Now, do not feel bad for Justin Lanasa, because I think he's going to land on his feet. Because you see, this tweet came out from Dungeon Hobby Shop Museum. Now, who could have been tweeting this? Well, there is a court order saying that the only person allowed to represent Dungeon Hobby Shop's social media is Justin Lanasa. So I think we can presume this to be from Justin Lanasa as per that court order in the Wizards of the Coast case. Dungeon Hobby Shop, I will be applying for the open position, FYI. And he's retweeting this. Hasbro announces resignation of Cynthia Williams, president of Wizards of the Coast and Hasbro Gaming. So don't worry about Justin. He's probably going to land on his feet. I'm just curious, though, how that interview is going to go. When they bring up the fact, aren't you suing us in $1 million lawsuit where we've already incurred $1 million in legal fees? You want to become president of the company? I would love to hear the reasoning for that. But he seems fairly confident. So new career for him at Wizards. Let's get in a couple more comments. I can't find that dork on YouTube. I don't know which dork you're referring to. And then Multiplayer Dungeon says, who in the world would feel bad for lasagna? Well, lasagna, I'm in favor of. I like lasagna, nice frozen Stouffer's lasagna, rather than have to work to cook something at night. Good wife and I split it. We love lasagna. Lanasa, well, I don't know. Apparently he's lost standing and respect in the eyes of his family members. So I think the list of who would feel sorry for him would be probably rather short. And he doesn't need anyone to feel sorry for him. He is, after all, the savior of the OSR. And
Oh,
yeah, that was from Dawn.
no, but the next one, wouldn't he actually have to do work at Hasbro though?
Probably.
Multiplayer Dungeon said.
Probably. He would probably have to do work. I don't know. I don't know what he thinks. Thumb down. The Emperor has voted. Cal, that is great. That was great. I love that. That's a great statement. So this is 30 pages, and the judge sprinkled through there little crumbs for the Bar Association in New York to take notice. I think it's kind of a hint, like the judge did not appreciate the lawyer's performance in this, that it was quite possibly something that should be referred to the bar. So those hints were there. And my phone keeps buzzing. I wonder if it's anybody important. No. So that's in there. The judge's irritation with the failure to follow rules, failure to do what he said. I gave
quantity
you
over quality.
Yeah. You're going to assign me work?
Yeah.
That's how that. You're going to list 100 YouTube videos for me to watch?
Plus, you never said any of it wasn't true. You just said, "Hey, he was mean to me," without.
Erik said bad words about me. Erik called me an ass. Rachel said she'd grow a cock just so Justin could eat it. Oh, I probably shouldn't have said that. But yeah. I mean, those were the words that were bleeped out in the thing there. I should have bleeped them out. I apologize. But yeah, Erik said bad words, and called them names, and then said some true statements about him, and then, said a factually true statement about the Dungeon Hobby Shop Museum. It's a for-profit museum. How is that defaming somebody to say that the museum is a for-profit? It's a factual statement. Justin's other museum, the Museum of the Weird, there in what town does he live in, Dave? I forget. Wilmington,
yes,
North Carolina, is a for-profit museum. So, yeah, free speech prevails. I don't know if you caught that, Don, but I actually referred to it as the Second Amendment. That's a whole different kind of speech, actually, the Second Amendment. But yes, free speech does prevail, as it should. And Erik did nothing wrong. And the judge has said nothing outrageous, nothing to see here. Move along, dismissed with prejudice. Get out of my court. I don't want to see you again. You can't reapply. You cannot refile. And so this was a total shutdown.
I don't think any of it was surprising, though. Like, we expected this judgment. It just was like, finally.
It took a long time. Even the judge said, finally. I love that. Even the judge said, finally. So I've got nothing more out of that. Good luck, Justin, with applying for the president of Hasbro Gaming and Wizards of the Coast. Good luck. Wish you well. And you certainly couldn't run it any worse than it has been run, I don't think.
Oh, don't challenge him.
Oh, are you saying that he just said, hold my beer?
Yes, don't do that.
Yeah, well, there was a recent Dork Tower cartoon over them. Oh, yeah, we're going to have AI write our adventures now. I love that Dork Tower cartoon. If you see it, it's making the rounds on social media. Yeah, that's, I mean, it can't get any worse than it is, but maybe it could. So,
so Multiplayer Dungeon is saying, so is your lawsuit dismissed then?
Yes, the lawsuit. Oh, I missed that statement. Lawsuit is dismissed with prejudice. Now, because Rachel was never formally served, the case against her was dismissed without prejudice. But for the people who were properly served, namely Erik, dismissed with prejudice, not allowed to reapply or to refile this case. So this is done, and Erik is unshackled. And I might add, I probably should put a link in the show notes, but Erik is going to be on tonight with Bad Mike. I imagine they might have something to say about this.
Possibly. Right.
More than a few hot takes, maybe. Nice. Reminds me of winning several legal battles with my old landlord. Very nice. It's a great weight off your shoulders. Yes. And, this has been something that I have wished for a long time. I've wanted to scale back. Erik never shuts up. Well, he did shut up for this case. He did have to shut up for this case. I've been wanting to back off on reporting on TSR, and people have been like, dude, you move on. And, look, it's a has-been case. TSR is a has-been. It's bankrupt. The CEO could not even manage the company to make a profit. He just managed a loss, a massive loss in bankruptcy. Yeah. Oh. He spoke in code. So I've wanted to, largely back off and just wait for really big news. Like, I think we're going to get some really big news in the Washington case. That's revving up. Rather interesting. And of course, the New Zealand, case is rather interesting. That, how much court, because can one guy go after how much, how much does he want himself in court? I don't know. I just don't know. So I'm just kind of tired of TSR and Justin Lanasa. And so I would like to hand the baton back to Erik. And largely, I stood in the gap while Erik was had this SLAPP lawsuit preventing him from participating in public speech and free speech on YouTube. A rich man using the courts of law to try to shut someone up by suing them and push them around and bully them around. And unfortunately, they misjudged with Erik. He is, he's a cop from the Bronx. You should have just known bullying a character like that is just not going to.
Because Erik is smart and knows the law. Like, he knows the law.
Yeah. So you just had to know that was going to fail. But I would like to hand off the baton a little bit to Erik and let Erik run the next couple of laps on TSR with the reporting, unless something big really happens in the realm of court. There may be things brewing that I can't speak about, so I won't. But there could be some big stuff around the corner. I think the Wizards of the Coast case is going to warm up and get hot and heavy and produce some interesting news. That's my prediction. But that's about all I can say right now. So this is Tom for Tabletop Taproom Court Reporting. The good wife.
Yes, who wants to say congratulations to Erik and Rachel.
We want to, yes, congratulations, Erik and Rachel. And we look forward to live streams with whatever comments you guys have. We're so glad you have been unshackled and ungagged and your free speech is restored to you. Have at it, buddy.
8:00 tonight. Tenkar's Tavern. Be there.
8:00 tonight. So signing out and keep on gaming. And yes, multiplayer dungeon. May all your rolls be crits. Be there for Talking Crit tonight, 8:00, Tenkar's Tavern.